Hi friends, today I am going to discuss about judicial activism. What is judicial activism and when it was started? Actually, it was started in America in 1947 and then it was started in our country also. So what is judicial activism? When judiciary takes actively participation in resolving the issues of citizens and to protect the laws, and it encourages in the actions of executive and judiciary and activism, executive and legislature. So judicial activism means proactively using their powers to make decisions that go beyond the just interpreting the laws, often addressing social issues, upholding rights and potential changes existing law policies. Actually, why judiciary has to take these kind of steps? Because when executive and legislature are not able to complete their actions and they are unable to hold the citizens rights and their fundamental rights. So for a country like India, judicial activism has been mandatory and it was started in America by Arthur Slanning Jr. He belonged to America, but later on it was adopted in our country also. And who is the profounder and pioneers of judicial activism in our country? In this matter, actually, P.N. Bhagwati, Justice P.N. Bhagwati, and another name is V.R. Krishna Nayyar, and another name was Justice D.A. Desai. These are the justice who just initiated this kind of things in our country. And in the name of, we can say that PIL. What is PIL? Public interest litigation. When a person or a group of persons are not able to file the case in High Court or Supreme Court, and when their rights are their rights are violated, then another person can file the case in Supreme Court and in High Court also. So that this is the best tool by which a person can protect and their rights or judicial rights. In this case, why it was necessary or why it was needed? Actually, what happens that executive do not fulfill their actions completely, and legislature also do not complete their actions easily, and the executive officers of the executive are very careless and they do not implement the laws easily. So in that case, judiciary has to take these kind of steps to resolve the problems of the society. In society, there are so many poor people who are economically very poor and their economic condition is not good, and they are not aware about the laws of the constitution. So in that case, a person or a group of persons can file the cases. In this case, so many PIs were filed in a judiciary also, like Keshwanand Bharti Banam in 1973 and Sheila Barse Maharashtra state in 1983. These were the we can say that PILs which protect a persons or a group of persons so that their rights can be upheld. And in this regard, I see Gopal Nath versus Punjab in 1963 and Hussainara Khatun versus Bihar State in 1979 and AK Gopal versus Madras 1950. Actually, in this case, what happens that a group of persons or persons were not able to fulfill their, they were unable to protect their fundamental rights. Then these PILs were filed in Supreme Court or High Courts. Actually, these things are very mandatory for us. And but on the other hand, in 2007, a restrictions in was also filed that when judiciary or when we can say that executive or legislature are not able to fulfill their requirements, then many things are done. But there are some instructions also that judiciary cannot uphold all the rights because it is the violation or encroachment of executive and legislature. So when what happens that when governments it is the violation of decentralization of the powers, because judiciary has different powers, executive has different powers, and legislatures have different powers. So judges must act in their limited areas. They are enshrined some laws in which they have to work in their limited actions and they should not encroach and they should not overreach the area of legislature and executive. So they must not act like kings, but they must just interpret the laws, and they must protect the fundamental rights of the people. In this case, actually, Vishakha guideline was also made by the High Court or Supreme Court, because what happens that many women are not, we can say that, safe in their workplaces. They are molested, they are tortured by the people. So this kind of case was filed in Rajasthan also, in which women were not safe in their workplaces. So if a woman is persecuted, molested or harassed, then she can file the case to protect their laws. And we can say that, but on the one hand, there is judicial review as well. Suppose if any law which is against the constitution, which is we can say that against the laws, and so in that case, Supreme Court or High Courts, Supreme Court has the power to nullify that case, to abrogate that case, so that the protects of people can be protected or our country can be protected, such kind of things. But what is the reason that in judicial activism was needed? Actually, there are some needed that judicial activism plays very important role in our country, because there is corruption in executive. Some officers are not able to fulfill the requirements of the people. Even some leaders are not able to fulfill the requirements of the people. They are very lazy, they are very sluggish. In such a case, Supreme Court has to take some steps and to protect the steps of the common people. So judicial activism in India upholds the rights of the citizens, and it makes the constitutional frameworks going beyond the traditional judicial functions. So it's the need of the hour. And if we want to maintain peace in the society, if we want to maintain the law and order in a sequence, then judicial activism is the best way. But on the other hand, judiciary should exercise their powers in the limited way. If the fundamental rights of the citizens are violated, if any law which is made against the constitutional framework or structure, then such laws must be nullified or abrogated by the judiciary. But it must be controlled. Their powers must be controlled, otherwise there will be hegemony in the society. So friends, I would like to say that judicial activism is the need of the hour, and it must be exercised, because everybody has faith in judiciary rather than executive and legislature. So it is mandatory that legislature and executive must perform their duties precisely or actively, so that the burden on the judiciary will be less. Now, so many cases are there in judiciary, and lawyers, we can say the judges are unable to give the decisions. So sometimes it is then very important issues are not heard in the courts also. So some important issues, hearing is not conducted on time. So if you want to maintain peace, prosperity and harmony in the society, then the role of judiciary is very mandatory. The role of judicial activism is very mandatory. So friends, I think that you must share these videos so that so many people, so many students will take the benefit of this. Thank you. Welcome.